Welcome to today's program titled Navigating Compliance with the Final Regulations to the Pregnant Workers Fairness Act. At this time, all participants are in a listen-only mode. We welcome you to follow up with your Seyfarth contact with any questions following the program. For those interested in obtaining CLE credit for this webinar, a CLE attendance verification code will be read later in the presentation. Please write this code down as it will not be reread and is required on the CLE credit request form. During the presentation, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Ellen McLaughlin. Ellen, please go ahead.
Thank you and welcome everybody. We are delighted to be providing you with this update on the PWFA final regs and interpretive guidance. Well, I'm going to speak first, but let me introduce you to my partner, Carla Grossenbacher in our DC office, where she chairs the firm's labor and employment practice there. She also heads the firm's National Workplace Privacy and Biometric team, and is both a litigator and trusted advisor in the L&E space. My name is Ellen McLaughlin. I'm a partner in the Chicago office, and I spend a lot of my time counseling on the ADA and FMLA, and now it looks like it will be also the PWFA added. I had the honor of testifying before the U.S. House of Representatives Committee on the PWFA. I wish they had a better acronym for that. It's too complicated. It's a bit of a mouthful. And at that time, it was the HR Bill 2694, all the way back in 2019. So it has taken quite some time for us to get here to the final regs and the interpretive guidance. And I do have to laugh, Carla and I have chuckled about this, that the final rule says that it should only take employers 2 hours to get up to speed on the final rule and the interpretive guidance. Well, let me tell you, it takes longer than 2 hours just to slog through the more than 400 pages, chocked full of everything. So EEOC, we don't agree with you. So hopefully this program will help condense that time period for all of you. Next slide. So here's our agenda. You'll see it's long, so we are going to just power through it, and that's the reason that we are not taking questions today. But again, feel free to reach out to your Seyfarth contact and we can get those answered. Next slide, please. So let's talk about the basics. Next slide, please. So the PWFA became effective last year, mid-last year. The EEOC proposed regulations in 2023 and issued its final rule along with the interpretive guidance, which is very helpful, by the way, on April 15, 2024, that becomes effective in mid-June. It's enforced by the EEOC and uses many terms and concepts from Title VII and the ADA, which you'll hear about today. In terms of filing a claim, employees similar to Title VII and the ADA do have to file an EEOC charge and exhaust their administrative remedies before filing suit in federal court. Carla will talk a little bit more about damages, but basically they are the same as under Title VII. Next slide, please. So what's it all about? This is it in a nutshell. The PWFA requires a covered entity to make reasonable accommodations to a qualified employees or applicants known limitations related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions, absent undue hardship. Really, that is the core of the PWFA. Next slide, please. So let's talk about the first concept here, which is what does pregnancy, childbirth, or related medical conditions really mean? Next slide, please. So here's the bottom line. It is a very, very broad list of conditions that are encompassed by pregnancy, childbirth, or related medical conditions. It picks up the same language that is used in Title VII. So the definition of sex, that's where it's picked up from under the final rule. So it's given the same meaning as under Title VII. Unlike the ADA, so you're going to hear a lot of comparisons today about what's similar and what isn't. There is no level of severity required to have, well, pregnancy, obviously, childbirth, or the related medical condition part. It can be a modest limitation. It can be minor. It can be episodic. Unlike the ADA, where you have to have a substantial limitation. So that is a major difference. So what are we talking about? These are some examples. Some are intuitive, some perhaps not so much, but it's a long list. So pregnancy and childbirth, current or past pregnancy, potential or intended pregnancy. So the PWFA does pick up infertility, fertility treatments, and use of contraception. Of course, labor and childbirth. Something relating to pregnancy includes lactation, miscarriage, stillbirth, having or choosing not to have, choosing to or to not have an abortion, or all of those complications that could be related to pregnancy. Now, there were, I think it was close to 100,000 or more comments received by the EEOC on the abortion issue. They took that into consideration, and there was a lot of debate between the Republicans and Democrats on that. But the bottom line is, unless somehow it's enjoined, which I don't think it will be, or I think this will survive here, it does include conditions related to having or choosing not to have an abortion. Next slide, please. Examples of medical conditions relating to post-pregnancy. Depression. I mean, I think we're all familiar with postpartum depression. Psychosis. Conditions related to lactation, low milk supply, engorgement, plugged ducts, mastitis. Examples of other medical conditions related to pregnancy, nausea or vomiting. So of course that picks up morning sickness, right? Frequent urination, incontinence, loss of balance. Oftentimes when a pregnant worker becomes more pregnant, sometimes their balance may be off. Vaginal bleeding and menstruation. What I'm giving you here is a non-exhaustive list. If you take a look at the final rule, it is very, very broad. So when you are evaluating whether or not somebody has this pregnancy, childbirth, those two are easy, but it's the related medical condition. Just remember that the intent is to be a very, very broad swath of lists. Next slide, please. So something to keep in mind that the medical condition does not need to be caused solely by or originally or substantially by pregnancy or childbirth. So a good example of this, I think, is if somebody had a bad back condition before they were pregnant, but pregnancy has exacerbated it, it doesn't matter that it was originally caused just by the person's physiology or injury. But if it's exacerbated by pregnancy, then the PWFA will attach. Now, the consequence of that is they may already have a reasonable accommodation in place under the ADA, but as you'll hear throughout the session, there is one major difference between the ADA accommodations and the PWFA accommodations. And so whatever accommodation you are granting or have granted under the ADA in this example may need to be modified or changed. And then I just felt I needed to include this because EOC had it in its rule, and I'm like, well, of course. But sometimes the of courses are good. The medical condition has to relate to the pregnancy and childbirth to be covered by the PWFA. So the example that the EEOC gives is somebody post-delivery is vomiting, but it's due to food poisoning and not related to their pregnancy or post-delivery. It's not covered. Now, frankly, I think we could have all figured that out, but that always is a question that you should be asking yourselves, is whether this related medical condition is due to the pregnancy or some other reason, but keeping in mind that it doesn't have to have originated from the pregnancy. Next slide, please. So I'm going to turn it over to my good friend Carla, who's now going to talk about known limitations.
All right. Hello, everyone. Let's move on to the next slide. I'm going to talk about known limitations because under the PWFA, that's what needs to be accommodated. So known limitation has two parts. There's a limitation, physical or mental condition related to, affected by, arising out of pregnancy, childbirth, or a related medical condition. But it also has to be known by the employer. And this isn't a materially different concept than what we're used to under the ADA, where you have to put your employer on notice of your disability. But here also under the PWFA, the employee or applicant or through the representative has to communicate the limitation to the employer. Next slide. So again, as Ellen mentioned, a known limitation doesn't need to meet that high ADA standard. In the comments that the EEOC received, people asked questions or raised issues about, did the limitation have to belong to the employee making the request? Or could someone say, you know, my partner is pregnant and this is going on and I need an accommodation as a result? So the EEOC modified the final rule to note that the limitation, yes, must actually be the limitation of the employee in question who is making the request for accommodation under the PWFA. Next. So the employee or the applicant can make the request themselves or have a representative do it under the PWFA. And in the final rule, the EEOC made a few changes, broadened the group of people who could qualify as a representative, adding union representative as at the request of several of the comments they received, and also other representative as sort of a catch-all, but B, also to capture the situation of an employer who uses a third party to process their accommodation requests. And so the employer applicant or representative can make those requests on behalf of the employer applicant. And the representative doesn't need permission in order to make the request on behalf of the employee. This is to take into account certain situations where an individual who has the limitation might not be able to make it themselves due to the limitation. They might be incapacitated in some way. So how does it need to be communicated? And the EEOC acknowledges that typically the limitation is communicated when the person is requesting accommodation. It's not usually, hey, I'm going to notify you of my limitation and one day I'm going to ask for an accommodation. It's usually all wrapped up together. But what's clear from the final rule is that there's no specific way someone needs to make a request under the PWFA. It doesn't have to be in writing. It doesn't have to be in a specific format or use specific words or be on a specific form. You need to think about it like you would a harassment complaint under Title VII, which doesn't have to take any form, but once it's communicated, has to be acted upon. Now, I know we all have processes, or most people do, for ADA accommodations, and they involve forms being filled out. And what the EEOC says is that's fine. You can request that the employee or the applicant or the representative fill out the form, but they don't have to. But you can make the point that it's easier for you to process and consider the request if it's all on the form. And the other thing an employer can do is also put it in writing back to the employee. So I heard you tell me that you have X limitation and you are seeking X accommodation, and get it in writing that way. And the employee can respond or not, saying, yes, that's what I said, or no, it's not. So to whom can the request be made? So of course it can be made to a supervisor or manager. One thing they changed in the final rule was that it's also anyone who regularly directs the work of the employee. So let's not focus too much on, are they a supervisor or manager under the NLRA or something like that. It could be a coworker who directs work of individuals, like a lead. Of course, it can be human resources personnel. Of course, it can be third-party agents of the employer, like that company that processes the accommodation requests, or other appropriate officials, again, a catch-all, or the employee can follow the policy that the employer puts into place, saying you should reach out to X, Y, and Z. So again, another kind of Title VII concept, making it easy to make the request, having a huge group of people that the request can be made to, so the employee always has someone to go to. Next slide. So I just pulled out an example that they give in the final rule. They give a lot of examples. The PWFA, actually the statute directs the EEOC to give examples in the final rule. So here's a simple one. You have an employee who's a police officer, they're pregnant, they go to their union, and the union rep makes an ask for a larger size uniform and vest for the employee. And that is a valid way to make a request for accommodation under the PWFA. She has a known limitation and it needs to be accommodated. Next slide. So let's talk about the very interesting topic of qualified individual under the PWFA, because this is one of the most significant ways in which the PWFA deviates from the ADA. Next slide. So the PWFA has an exception to the generally recognized rule that someone needs to be able to perform the essential functions of the job in order to be accommodated. That's the rule under the ADA. But what the PWFA says is that there is an exception, and that an employee can still be qualified even if they are not able to perform the essential functions of their job due to the known limitation, if the inability to perform the essential function is temporary, they will be able to perform the essential function in the near future, and this inability to perform the essential function can be reasonably accommodated by the employer. So one thing to keep in mind about this particular exception is how it got here. When the PWFA was introduced into Congress, it had no requirement whatsoever that employees need to be able to perform the essential functions of their job. If you ever go back to the legislative history, you'll see in the House Committee report that our very own Ellen McLaughlin testified before Congress, as she mentioned, and they cite this in the House Committee report because Ellen pointed out, well, gee, this is sort of a big part of the ADA, and it's completely missing from a statute that is supposed to be, quote unquote, based on the ADA. And so a bipartisan negotiated exception was created as a compromise between the people who thought, no, we don't need an essential function requirement in the PWFA, and the people who said, well, the PWFA is, you're right, it's a mouthful, Ellen. The PWFA is supposed to be based on the ADA, and so we need that essential function. So this is a compromise, a negotiated exception, and to qualify for the exception, you need to meet these three criteria. So let's go to the next slide. So temporary, the EEOC says in the final rule, is just your average Webster's dictionary definition, lasting for a limited time, not permanent. So what does in the near future mean? Because the employee has to show they will be able to perform the essential functions of their job in the near future. Well, the EEOC modified what they had in the proposed rule, which was basically that in the near future generally means 40 weeks. In the final rule, they say, well, for current pregnancy, if what we're dealing with is an employee who is actually pregnant in the near future, has to mean 40 weeks. It has to mean the entire duration of the pregnancy, conception to birth, because otherwise you're going to put employees in the situation of saying, well, I can't get it for the full length of my pregnancy. So I'm either going to put off asking for the accommodation or ask for it now and work when my accommodation is used up and I'm no longer qualified and my temporary exception has lapsed. And the EEOC says, no, we can't make people put their health at risk. They need to be able to have the whole 40 weeks. Now, this doesn't mean that anytime someone has a temporary inability to perform their essential functions that they automatically get 40 weeks, but that is the outside of in the near future for a currently pregnant individual. Anyone else, if it's a pre-pregnancy or postpartum issue, that is determined on a case-by-case basis what in the near future means. So that interactive process is going to become important for determining whether an individual is qualified if they want to say that what the issue is they can't do the essential function right now temporarily, but can in the near future. So what are the various ways this can play out for the employer in ways that maybe we think weren't entirely intended? Of course, there can be stacking, right? So I can't do this essential function for 40 weeks due to this limitation. So maybe I have that back problem, but now I have a different limitation. I have a weightlifting restriction and I can't do this for another 40 weeks because of this. So it's not tied to one limitation. In addition, multiple essential functions can be affected. So I can't do this one for 40 weeks. I can't do that one for 40 weeks. And the determination of whether someone is qualified and if they can perform the function in the near future is made at the time of the employment decision. Always a new clock being set when a new request for accommodation is put forth. Next slide. So of course, there are two backstops to this issue. And again, I want to emphasize this is just in determining whether someone's a qualified individual under the statute. Okay, so let's say they have a temporary inability to perform their essential functions, and they have shown that they can perform that essential function once again in the near future. Now the employer has to determine whether they can reasonably accommodate that inability to perform the essential functions. And then there is another determination of whether that accommodation would result in undue hardship. So what are the types of reasonable accommodations for someone who is temporarily unable to perform the essential functions? Well, the EEOC says temporary suspension of the essential function, assigning it to someone else temporarily, or putting that employee in a job where they don't have to do that duty, or light duty. And people scratch their heads, they read this and they say, but hey, that's not required under the ADA. Well, under the ADA, there's no qualified individual exception for temporary inability to perform the job. So if the person qualifies for the exception to qualified individual, these are the types of accommodations you need to look at. Next slide. So again, undue hardship is always the ultimate backstop on providing an accommodation under the PWFA, under the ADA, has the same definition here. Factors that employers can consider under the final rule. How long will they not be able to perform the essential function? Even if it qualifies as in the near future, it could still pose an undue hardship. Whether there's other work for the employee to do, how often they perform this particular function. Is it a small part of their job, even though it's essential? Can others actually do the work for the individual? And whether the employer could just say, that's okay, we don't actually even need you to do that for the next however long they're asking for it, 10, 20 weeks, let's say, that we can just wait for you to do that when you're able to do it. So all these things need to be evaluated. Next slide. So again, some examples from the final rule. This one is a employee who's a nurse. Nurses often have to lift a good deal of weight in order to maybe turn patients over in a bed, dress and bathe them. The employee here is pregnant and sends an email saying that she needs to be exempted from lifting more than 25 pounds. And the employer has an established light duty program. And under these circumstances, the EEOC would say she's qualified and the accommodation must be granted absent undue hardship, and it doesn't look like undue hardship when there's a light duty program in place. Let's go to the next slide. One more example, this one involving a farm worker who works outdoors. She returns from giving birth and has postpartum thyroiditis, which makes her sensitive to heat and makes her weak. She asks for an accommodation of a temporary suspension of her essential function of working outdoors for 7 months. And the EEOC says she's qualified because that's in the near future for her, and accommodation must be granted absent undue hardship. Next slide. So let's go back to Ellen for reasonable accommodation in the interactive process.
Thanks, Carla. So next slide, please. So the good news is that reasonable accommodation generally, with that one major exception Carla just went over, not having to do an essential function for that temporary period, generally is the same concept. But that is a big exception, right, between the ADA and the PWFA, big difference. So I do think that one of our next steps you'll see at the end of the program is really that whatever universe of individuals you typically train on managing within the law, this really needs to be added, and frankly, maybe just do a standalone session, because we certainly don't want managers, for example, if some employee, pregnant employee comes to them asking for an accommodation, to be putting them out on leave right away. So I do think training on this significant difference is something that really needs to happen. As Carla said, we still, thankfully, do have the absent undue hardship defense, and thankfully, similar to the ADA, an employer still has the discretion to choose between effective accommodations. Now, in the final rule, the EEOC danced around this a little and said, well, but that's true, but you should give the employees choice preference, primary consideration in all circumstances. And then in the next breath, they said, but of course, if the employer wants to choose an effective accommodation that is less expensive, that's okay. That is better for the business, that's okay. And the good news is, at the end of all this kind of going back and forth in the final rule, the EEOC said, but you know, if the employer chooses an effective accommodation that works for the pregnant employee, it does not have to prove undue hardship in terms of why it picked their choice, but not the employee's choice of accommodations. In other words, the accommodation the employee preferred doesn't cause an undue hardship. We don't have to go down that path. So that's good news there. Next slide, please. So the interactive process, another bit of good news, should really be similar to what your organization is using for ADA requests, with some of the modifications we're talking about today. And throughout the final rule and in the interpretive guidance, the EEOC continues to say this really should be simple, because it is, you know, something for a temporary period of time. We, EEOC, are expecting these to be simple conversations between the employee and employer. And I think in many cases, it will be, in some cases, not so much. So what I always say, I picked this up from an ADA deck that I do. It's like dialogue, 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 right? Between whoever is responsible for the interactive process, working with the pregnant worker, if it is more than I'll call a just do it accommodation, and again, consider training on how to handle these requests and the accommodation differences. Now, similar to the ADA, there is no standalone violation for failing to engage in the interactive process, but do be wary of the consequences of an undue delay, which can result in a claim under the PWFA. And that really is a very similar concept to the ADA. Next slide, please. So let's talk about leave. I do think that some employers and oftentimes really managers want to put a pregnant worker out on leave rather than having to accommodate them. And that was really one of the reasons that the PWFA was proposed in the first place, because many pregnant workers were forced on leave, weren't getting a full paycheck. And with removing an essential function, which is what we're left with here, they could stay on the job. So leave is an accommodation of last resort under the PWFA. You know, we always say under the ADA, job reassignment is the accommodation of last resort. Where here under the PWFA, it is leave as the accommodation of last resort after everything else has been exhausted as to how to keep that pregnant worker working. Now, if they are placed on leave, and sometimes, you know, of course, it may be that the individual raises their hand and says, my doctor says that I'm having a very complicated high-risk pregnancy. I need to go on bed rest. Well, obviously there, right? That's what the employee wants and needs. But if, regardless, for the reason they're placed on leave, they are entitled to return to their same position upon return to work, unless the employer can show that holding the position open created an undue hardship. And given the temporary nature of these accommodations, that likely would be very difficult. But again, we still always have that defense. And this really is also a concept both from ADA and FMLA, that you can't penalize someone who takes leave or has to have more breaks, bathroom breaks, food breaks, whatever it may be, in terms of their production, their sales quotas. You can certainly expect them to satisfactorily perform those functions, but you may need to prorate their production given the leave that they're taking or the breaks that they're taking. And so always keep that in mind. But again, that is a concept from FMLA as well. Makes total sense. You can't do 100% of your production if you're not there 100% of the week, or if you are taking more breaks, such that if you are really evaluated more so in hourly increments, you're not working as many hours. So just keep that in mind. Next slide, please. So here's an example of penalizing an employee. And I would, it's interesting bedtime reading to go through the examples in the interpretive guidance. There's all kinds of content in between them, but they really do tell you, sometimes you're not going to like what the EEOC says, that, and remember, we can always, kind of challenge these. This guidance is, the final rule is not law, nor is the interpretive guidance, but it does tell you what position the EEOC is going to take in litigation and certainly at the charge level. But read through the examples. They are very instructive. Here is one about penalizing employees. So we have a FIFA, a customer service agent who's pregnant, needs 2 additional 10-minute rest breaks and additional bathroom breaks as needed during the workday. And the employer says, fine, no undue hardship there, and grants the request. But because of the additional breaks, he's responding to 3 fewer calls during a shift. And so her supervisor gives her a lower performance rating because she's not meeting her productivity metric. Okay, that would be an example of penalizing the employee for using the accommodation that they asked for and were granted. So of course we can't do that. Next slide, please. So this is going to be, next slide, the whole list of reasonable accommodations that are in the final rule. It's a non-exhaustive list of examples, and you will see that many of them are the same ones that we look at under the ADA. Frequent breaks, but oftentimes it's for different reasons. Now, frequent breaks due to fatigue, due to needing to go to the bathroom more frequently, needing to pump, If you're in a sitting job, needing to stand more, in a standing job, needing to sit more, a schedule change, remote work. We're going to get to that in a little bit because I know that is a hot button for most employers that we are working with respect to all of the requests to work from home, a close-in parking space. Carla talked about the light duty, making existing facilities accessible and having to take the elevator, no exposure to fumes, job restructuring. Now, of course, the one that's in green there is the big one, right? Temporarily removing an essential job function. This is at the core of the PWFA. And I think, again, you're going to hear it probably 10 times over from me. One thing that is so different that we really need to make sure that everybody who touches any pregnant worker's request for an accommodation is fully aware of. And of course, modifying policies, modifying equipment, uniform devices. The one I think I will add here is this temporary reassignment to a vacant position, which Carla talked about. Many employers that I work with do not favor that because it is a temporary reassignment to a vacant position, and they really want to fill the job with someone who is going to be in it long term. Now, remember, we always have the undue hardship defense here, but this temporary reassignment to a vacant position is an accommodation that you would need to consider. Next slide, please. And back to you, Carla.
Okay, so we're going to talk about unnecessary delay, and as part of that, interim accommodations under the PWFA. Next slide. So unnecessary delay in granting an accommodation or ruling on an accommodation request under the PWFA can in and of itself violate the law. So even if you ultimately grant the accommodation, but you take too long to do it, you can violate the PWFA. And again, this goes back to safety of the employee, and that's what's driving the unnecessary delay, as well as the interim accommodation concerns and issues under the PWFA. Let's go to the next slide. So factors in determining whether there has been an unnecessary delay are the reasons for the delay, exactly how long you delayed, versus the length of time the accommodation is needed. Because if it's only needed for a short duration and you take up most of that time trying to determine whether you're going to grant it, you can see how that could, in some situations, effectively be denying the accommodation. Who contributed to the delay? Is it all on the employee side or is it on the employer's side? And the last factor to be considered, moving to the next slide, is whether an interim accommodation was provided. And again, this goes for the health and safety of the employee. The idea is we don't want pregnant employees putting themselves in jeopardy by continuing to work when they've asked for an accommodation pertaining to how they work and the conditions under which they work for the safety of their pregnancy. We want employers to either rule promptly on the accommodation request or provide an interim accommodation. So one factor in determining whether there's an unnecessary delay is whether an interim accommodation was provided. And of course, if one was provided, then it's less likely the delay will be considered unnecessary. So this is basically incentivizing employers to provide interim accommodations while doing things like waiting for documentation in the circumstances under which you can request it. And Ellen's going to talk about that later. Pending a decision, it's got to go through your process. Maybe someone's on vacation. There's always an opportunity for some sort of delay or hiccup in the process. Or you could be waiting and ordering a piece of equipment that's needed for the accommodation. So these are all examples of times where you could offer an interim accommodation. So interim accommodations are not required. Again, it's just one factor in determining whether there is an unnecessary delay. And of course, as Ellen said, leave is unfavored under the PWFA, so leave is not going to be considered an appropriate interim accommodation. Next slide. So here's an example from the interpretive guidance of the EEOC on reasonable accommodation. So we have an employee who's pregnant. She drives a delivery van, and sometimes it is very hot in the van with temperatures over 100 degrees. So the employee tells her supervisor she's pregnant and needs to have an option to have a cooler environment in which she is working. So the supervisor grants the accommodation request and orders a personal cooling vest or neck fan for her, but it's going to take a while to get it. They don't have this laying around. And so in this situation, the EEOC says, if there's no other possible work for this employee to do and she cannot be in that van due to the temperature, the employer could tell her that she may take leave while waiting. Note that the guidance says may. Again, it's not forcing her. She's going to make the choice in consultation with her doctor, but the employer can tell her that that is an option for her. Next slide. So here's another example, same type of example, same employee, same situation, but in this example, office work is available. And the employer tells Noor that she can't work in the office where it is cooler and air conditioned, because then everyone's going to want to come here and do it. And that is not an appropriate consideration under the PWFA, not really under the ADA either. And if they deny her accommodation request on that basis, that would be a violation of the PWFA. Next slide. So undue hardship and predictable assessments. Let's go to the next slide. As referenced earlier, undue hardship has the same definition under the PWFA that it does under the ADA, just like reasonable accommodation and interactive process, all borrowed from the ADA. So as many of you are familiar with, undue hardship under the ADA means significant difficulty or expense to the employer. Factors that you can include under the PWFA that are mentioned in the final rule are how much the accommodation costs, how much money the employer has, the number of people at the location, and also how is this going to affect the operations of the employer? How is it going to affect the other employees in their ability to do their jobs, and how the employer conducts its business? So these factors are generally the same kind that you consider under the ADA, and it's a high standard. We always tell people under the ADA, undue hardship is a very high bar to meet, and that's no different under the PWFA. And as the prior example I gave you under unnecessary delay, potential for other people to request the same accommodation is not an appropriate consideration for undue hardship under the PWFA. The final rule makes this clear. So we can't go around denying accommodations on the theory that everybody else is going to want the same thing. Next slide. So the PWFA has this new concept, again, something that you won't find under the ADA, of predictable assessments. And predictable assessments are reasonable accommodation requests that, in the EEOC's opinion, will be reasonable and not present undue hardship in, quote, virtually all cases, close quote. So what are those predictable assessments? Allowing an employee to carry or keep water nearby and drink it as needed, additional restroom breaks, allowing an employee who normally sits to stand, who normally stands to sit, and allowing the employee to take additional breaks to eat or drink, all on an as-needed basis. It is not reasonable to request documentation for a predictable assessment, and Ellen is going to talk in more detail about that, but the EEOC's theory with these predictable assessments is that they're simple, they're inexpensive, and basically everybody knows that pregnant employees need these type of accommodations. And so they just want to cut to the chase, and they just want employers to provide these accommodations without going to the employee for documentation, without going through a process, without delaying it, because the EEOC says in virtually all cases, this is going to be reasonable. Now, A lot of the comments to the proposed rule in which this predictable assessment, terminology was revealed for the first time. A lot of the comments, including ones that we wrote, said, hey, you're just bypassing the interactive process. And that's a core concept under the ADA. It's a core concept under the PWFA. You can't just walk around telling people there are such things as per se reasonable accommodations. There are thousands upon thousands of employers out there, and you, EEOC, can't predict what is going to cause an undue hardship for them. And the EEOC basically said, hey, we never said that. We never said it was a per se accommodation. Of course, you're going to do a case-by-case assessment. Of course, you're going to go through the interactive process. But what we are telling you is what we said before. In virtually all cases, this is going to be reasonable, and this is not going to cause an undue hardship, these 4 things that you see on the slide. So if you're an employer who's going to take the position that one of these 4 predictable assessment accommodations is going to cause undue hardship, you better be prepared to make a very convincing argument about why you can't provide these 4 requested accommodations. Next slide. So I thought it was interesting reading the preamble in which the EEOC in the final rule talks about all the other proposed accommodations that people who submitted concepts thought should also be predictable assessments. Because of course, in the comments that we submitted, we said, we don't even think these 4 should be, predictable per se accommodations. But I thought it was interesting that there were a bunch of other comments proposing a bunch of other predictable assessments. And I put them on the slides here, and I'm not going to read them. But again, because like Ellen was saying, this is a preview into the EEOC's mindset. They are the first stop for any employee who has an issue. They are going to process the charge. And even though their position in the final rule is not law, and goodness knows there are a number of situations in which courts have rejected the EEOC's interpretation of the laws it enforces, it gives you some insight to know that the EEOC basically agrees that the accommodations on this slide and the next, and let's flip to the next slide, are all things that are common, simple, and present little difficulty. And the only reason they're not being included as a predictable assessment under the PWFA in the final rule is because they weren't mentioned in the legislative history. So the EEOC says we're not going to put them in, but hey, people writing the comments, we basically agree with you that these are all common, simple, and shouldn't present difficulty for an employer. So you see it's stuff like 16 medical appointments, 8 weeks of leave. So it's interesting to get that preview into what the EEOC is going to think is an accommodation that isn't supposed to cause the average employer a problem. Next slide. So here's an example from the final rule on predictable assessments. You have an employee who experiences swelling, which is not unusual during pregnancy, and she has to stand for long periods for her job. So she asks for a stool so she can sit down. And they say that this is, one of the predictable assessments, and it's almost always going to be reasonable. And the employer says, well, gee, we've never given anyone, in our facility a stool. But that kind of thinking, and again, this goes to training of individuals, is not going to carry the day. The EEOC's position is, doesn't matter if no one's ever had it or you've never thought of it. This is what we think is a predictable assessment. And if you're going to take the position that it's going to pose an undue hardship, you're going to have to come up with something more than we've never done it before. Next slide. Here's another example for predictable assessments. This is a teacher who typically can only go to the bathroom during her breaks because she's in a classroom needing to monitor the individuals in there, and wants an accommodation that allows her to have more frequent bathroom breaks. And in this situation, there are several teachers in nearby classrooms, there are aides in the classroom, there are administrative assistants, all who could jump in to supervise her class while she goes to the restroom. So again, this predictable assessment type accommodation of more frequent bathroom breaks would not pose an undue hardship in the EEOC's view under these circumstances for the employer. Next slide. And another example for predictable assessments. So you have an employee who needs to maintain regular water intake throughout the day. Again, not an uncommon issue for pregnant individuals. They ask if they can have an exception that allows them to have liquid at their workstation. Now, the manager says, okay, I hear you, but I'm not going to allow you to bring it into the workstation, presumably maybe for safety reasons. And he proposes that a table be placed just outside of her workstation and gives her permission to go back and forth to the table to get water. And again, going back to what Ellen said in terms of we don't have to give the exact accommodation as long as we give an effective accommodation. The EEOC in this example says the employer has complied with the PWFA because its accommodation serves the same purpose, but does it in a way that's presumably more effective and compliant for the employer. Next slide. All right, let's go on for documentation, a fascinating topic.
Yeah, a fascinating topic. And generally, next slide, please. Many of the concepts are what you're used to, but I would say the sea change here is that there are lots of times where the EEOC says you cannot get documentation, or it is extremely limited in terms of what you can get and how you get it. So they keep stressing, things are supposed to be simple. And likewise here in documentation, they say, hey, you don't have to ask for it. And I think there are many times you wouldn't. If there is an obviously pregnant employee who says, I need a bigger uniform, I mean, they would say you can't get the documentation then at all, but why would you ask for it, right? So you're permitted to do so only when it's reasonable under the circumstances, and we relate back to the core, right, the core definition there. But not only does the circumstance have to be reasonable, but the documentation has to be reasonable. And again, to me, that's a concept picked up both really from the ADA and FMLA. You shouldn't be asking for somebody's medical records when they're asking for an accommodation for their pregnancy where they may be having severe morning sickness, and you just need to know from the doctor what's going on there. And of course, you have to provide them a reasonable time to submit the documentation. Next slide, please. Now, a bit similar to the delay, which may cause you to get in the crosshairs of the EEOC, likewise, seeking documentation that goes beyond what is permitted, regardless of whether the accommodation is granted or whether the employee actually provides the documentation, right, can be evidence of coercion under the PWFA and would be a claim for that. Be mindful of the ADA's limitations on the employer's ability to make disability-related inquiries or require medical exams. You can't require a medical exam under the PWFA. Similar to the ADA, there are certain limited circumstances there, but we're not going to go down that path. And really, we just want the documentation that shows what known limitation that they have and how to accommodate them. So the EEOC also says, hey, employers, be mindful that early in employees' pregnancy, it might be difficult for them to get an appointment with their healthcare provider and to get the documentation that you're after. And there they say, hey, best practice, not required, is to grant that interim reasonable accommodation that Carla talked about just a few minutes ago. Next slide, please. So we're back to EEOC saying this should be a simple exchange of information. Sometimes it isn't. And here's when you could get from a healthcare provider better information about what an employee is asking for. So you have someone who is pregnant and they ask for the temporary suspension of the essential function of climbing ladders due to dizziness and danger of falling. Well, there, good news, I think the EEOC says, yes, you can confirm the physical or mental condition, and there it's the dizziness and increased risk of falling really is related to the pregnancy, right? We're back to that tie into the pregnancy with asking the healthcare provider to describe the change at work that is necessary. So that's an example of when asking for documentation would be considered reasonable under the circumstances. Next slide, please. What's reasonable documentation? Well, it is to describe the change at work and expected duration of the change and adjustment and other details. So similar, right, to the FMLA really and the ADA. We need to know how long this is going to last. We need to know the details regarding the accommodation that is requested. That's fine. I had to laugh a little bit. The EEOC said, and you can't ask the employee to take a specific test to confirm their pregnancy. You can't ask them to give you a picture of their sonogram. And my sort of response to myself was, who would do that? But nonetheless, EEOC says you can't ask for a specific test for the pregnancy. And this one's an important one, no specific form. So this could be an oral exchange of information. People have been asking us, like, well, what form should we use? Well, this is really going to be, you can create a form for use under the PWFA, but I think it will need to be modified and tailored for each situation, frankly. In any event, the forms that you use should not reference serious health condition under FMLA and should not reference major life activity under the ADA, because those are not concepts that we are using here. So if you are modifying either of those forms, be very, very careful. Frankly, I would start from scratch, because I think you're going to get yourselves into trouble, because those FMLA and ADA forms generally are very heavy in those statutory concepts. Next slide, please. So there is this concept under the PWFA that in many cases you can ask an employee for self-confirmation of their pregnancy or any adjustment that they might need to the workplace. That self-confirmation can be oral or written, not in any specific format. And you'll see with the predictable assessments, or I call them the EEOC's just do it, many times what you can get from the employee is a self-confirmation. Next slide, please. So there's a lot more provisions in the rule and the interpretive guidance about what isn't reasonable documentation and what is reasonable documentation. So let's just quickly go through 5 examples where the EEOC, and these are the only 5 examples. I'm sure they're going to say there's more times that you can't get documentation. The first is when the physical or mental condition, the pregnancy, is obvious, right? You don't really need documentation for that. If you want, you could get the self-confirmation from the employee. Not sure why you would if somebody is visibly pregnant and it's that uniform, different size. The employer already has sufficient information, perhaps from an STD process if the employee has already taken some leave time. Why would you ask for more information under the PWFA? Predictable assessments. Okay, so you cannot ask for documentation other than a self-confirmation for the predictable assessments. There are limited exceptions to that if you were, and Carla and I did a program, 3-hour program with Sharon Tajani from the EEOC, who was one of the primary drafters and in charge of these final regs. And I said to her, okay, well, Sharon, really, if an employer, let's take the example of restroom breaks and breaks to eat and drink, can't the employer get documentation from the healthcare provider as to how many breaks they're going to need and frequency of the breaks, so frequency and duration of the breaks? The response was no, they can't. No documentation from the healthcare provider, and you can and should talk to the employee about frequency and duration. Now, I'm not frankly sure that that position will hold water, but that is the EEOC's position. When you want details regarding a predictable assessment, you get them from the employee. You don't go to the healthcare provider. You can get a self-confirmation. Next slide, please. Lactation. Why would you get documentation from the healthcare provider? Somebody comes back after having a baby. They say, I need some breaks to pump. You can get a self-confirmation. It includes not only pumping at work, but the EEOC says there may be certain times when, if there's a daycare center on site and the employee can actually breastfeed the baby rather than pump, all they have to do is say, so I want to pump, I want to breastfeed at work, my baby is in close proximity, and that's good enough. That's that self-confirmation. And if you have a policy that you don't require documentation for a non-pregnant worker seeking a similar accommodation, you should not get it for the PWFA request. Next slide, please. So in terms of who qualifies as a healthcare provider, it follows the ADA policy guidance. I have highlighted there, lactation consultants and doulas were added. And the healthcare provider does not need to be the person who is treating the employee at the time that they fill out any documentation, as long as they confirm the condition, pregnancy, and the accommodation that is needed, and you cannot require a medical diagnosis. Next slide, please. So this is a simple one. Basically, this slide could be condensed into one sentence. It would say, you follow the confidentiality provisions that are under the ADA for the medical documentation and information under the PWFA. Enough said there. Next slide, please. PWFA and other laws. I'm going to start and then hand it off to Carla to end our program today. So let's talk about, next slide, the Pump Act. So the Pump Act, of course, is enforced by DOL, right, not EEOC, and you have to provide employees with reasonable break time to express breast milk for a nursing child for 1 year. So this point's important, 12 months after the child's birth, and the breaks do not have to be paid. The room that you have to provide them, it doesn't say really too much. It should not be a bathroom, shielded from view, free from intrusion in the public, so that somebody can pump and not be interrupted, and nobody can see into the room. Next slide, please. So the EEOC has gotten into the act here because lactation, right, is a physical or mental condition related to pregnancy. So all of the protections of the Pump Act and similar state laws, of which there are many now, for pumping are unaffected by the PWFA, and whoever has the greatest protection by those laws applies. Next slide, please. So the PWFA rule and interpretive guidance says, okay, but these are possible other accommodations, really not other. These are possible accommodations under the PWFA for pumping. And you'll see here, it is really providing additional detail on the room, right? The room. So reasonable proximity to the employee's usual work area, regularly cleaned, has electricity, a sufficient countertop generally to place a breast pump, proximity to a sink, running water, and a refrigerator. And then we have the accommodation that speaks to if the baby is close enough to the workplace that you can actually nurse, would be an accommodation. So just keep in mind that while we have the very kind of scaled down requirements of the Pump Act, the PWFA does say, well, there may be other accommodations that you will need to make for a lactating employee. Next slide, please. So here's an example, and I think we've gotten a lot of these in the last year or so. This is somebody who is experiencing nausea and vomiting in her first trimester. The nausea makes commuting extremely difficult. She makes a verbal request to stay home for the next 2 months so she can avoid the difficulty of commuting. Now, we have this commuting both with respect to just generally or under the Pump Act. I'd rather be home pumping or breastfeeding my baby. And here the billing work can be done from her home or in the office. The EEOC says, well, if it's not an undue hardship to not be in the office, then you should allow this employee to work from home, even though really what is at issue here is the commuting, right? It's not the actual doing of the job. And so we have the EEOC taking the position that commuting is an essential function, in which case we have to grant the accommodation. Next slide, please. Another example with the Pump Act, somebody wants to pump for longer than the 12 months, and there's a couple of examples in the rule here. And basically, the EEOC says, so hey, unless it's an undue hardship, that employee gets to pump beyond the 12 months under the Pump Act. Next slide, please. Okay, I'm going to turn it back to Carla to kind of summarize our differences, and then the fun will stop and everybody gets to go back to their other jobs, their other advice, counsel, etc. But it's certainly been a lot of fun with you today.
All right, so PWFA and ADA, we've touched on this throughout the program. But again, ADA focuses on a disability, which is a physical or mental impairment that has a certain severity level, substantially limits a major life activity. The PWFA is a physical or mental condition that triggers the ability to request an accommodation. Condition, not impairment, no severity level required. PWFA borrows terms from the ADA, like interactive discussion, undue hardship, reasonable accommodation, but it has a different definition for qualified individual. Remember, there can be a temporary inability to perform the essential functions of the job, and the employee can still be qualified, which is not the case under the ADA. Could someone have a known limitation under the PWFA that's also a disability under the ADA? Yes. Gestational diabetes is just one example. So they may be covered under both. Next slide. PWFA and PDA, how do they relate? Pregnancy Discrimination Act is part of Title VII. PWFA is its own law. The PDA is a non-discrimination statute. So to the extent you are entitled to reasonable accommodation under that statute, it's only insofar as you can point to a non-pregnant person who's getting the accommodation you are requesting and is similar to you in their inability to perform work. It's a non-discrimination statute. As Ellen mentioned, the PWFA borrows the terms pregnancy, childbirth, or related medical condition from the PDA, but PWFA is broader. It's because the pregnancy, childbirth, and related medical conditions have this broader language of related to, affected by, or arising out of pregnancy, childbirth, or related medical condition. Next slide. PWFA and FMLA. FMLA provides unpaid leave when you have a serious health condition. Could you have a serious health condition that is also a known limitation under the PWFA? Yes, but remember, PWFA leave is a disfavored option as an accommodation, always an accommodation of last resort, but leave under the PWFA could count as leave under the FMLA. Next slide. And then lastly, a quick slide on what are the unlawful employment practices, because sometimes it can be, you get lost in all the terminology, qualified individual, when can I request documentation? I have on the slide for you here a quick reference as to what is actually illegal under the PWFA. So you can refer to that, and I won't read it to you. You can see it and refer to it later. We will obviously be circulating the PowerPoint to attendees and registrants. Next slide. Same here, just a list for your reference of all the different ways that the PWFA can be violated. So again, just keep these in mind because they play out over the course of interpreting all the other things we've gone over today. Like Ellen gave the example of requesting documentation from someone when you shouldn't. That could be considered intimidation, interference, coercion, because they're less likely to make an accommodation request if you're always going to worry them with documentation when you're not supposed to under the PWFA. Next slide. Damages under the PWFA are the same as under Title VII, all the types of things that you're familiar with under the discrimination laws, back pay, front pay, compensatory damages. The same exception that exists under the ADA for good faith efforts to provide reasonable accommodation apply under the PWFA, which are an exception to the imposition of damages. Next slide. All right, next steps for employers. Moving to the next slide. Remember, it's implementing a PWFA policy. If you have a reasonable accommodation policy, you can fold in PWFA language. Train your managers in HR. If they don't know things about predictable assessments, when they can require documentation, etc., they're going to get tripped up very early on when people are requesting accommodations under the PWFA. And then, of course, any forms that you have, again, you can't make people fill them out, but they shouldn't be the same ones you're using for ADA and FMLA because the terminology and standards are different. So those will need to be revised. Next slide. And here is your QR code for the CLE credit. You can just hold your phones up, get them out, and scan that in. I will also read the code. The CLE code is SS, like Seyfarth Shaw, 0523. SS 0523. So if you want to get your cameras out and take a picture of that QR code, do so now. The final slide is just a list of PWFA resources from the EEOC. Again, those will be circulated with the slide deck from the presentation, so you'll have them there to reference and go to if you want a little refresher. So on behalf of the firm and Ellen and myself, thank you so much for attending the webinar today. I know we went a little over, but hopefully you found it helpful in moving forward to navigate compliance under the PWFA. Thank you so much.
Thank you, everybody.